Right now, though, we are following up today on some high-profile cases that get national attention and some major updates in them today. We're talking about the cases against Luigi Mangione, who is accused of killing the UnitedHealthcare CEO, and we're also talking about the case of Tyler Robinson, who is the accused Charlie Kirk shooter. So a couple of updates in those cases and some major developments in that. And so joining us live now to talk about these cases, what we know about them, and what some of these terms mean as well. We are pleased to be joined this afternoon by defense attorney José Rivas, who is joining us live now via Zoom. And Jose, always good talking with you. We appreciate you joining us here on Florida Live.
Pleasure to be here today.
So first, Jose, let's start with the Luigi Mangione case, finding out today that he's going to use a psychiatric defense in that murder case. First of all, explain to us what this means and what that might look like in this case.
Well, New York is very unique in that they have what we call an affirmative defense. It's an extreme emotional disturbance. And what that means is that the defendant was in some kind of extreme emotional state causing a profound loss of self-control. In other words, there's reasonable explanation that the emotional state from the defendant's viewpoint. In other words, it's a partial defense that the defense must prove preponderance of the evidence. So it's a very low standard. But that doesn't mean that he gets acquitted if the jury buys the idea. What it means is that it goes from murder to a first-degree manslaughter, which would reduce his sentencing from life down to a maximum of 25 years.
And so what would the defense then have to prove, or how would they go about proving that he was going through that emotional disturbance or distressed state, whatever the exact wording is? How do they go about showing that?
Well, again, extreme emotional disturbance. They're going to bring in experts. It's going to be a battle of the experts. They're going to bring in an expert to testify, and at this point, we don't really know what the emotional disturbance is yet. And now, New York has certain, statutes and certain exceptions. For example, if you find your gender orientation, that's not an excuse. But the defense is going to come in. He's under this emotional disturbance, which he lost self-control. That's what the defense needs to prove. Now, the prosecution is going to say, he has self-control, and how they're going to disprove the defensive theory is going to be how he planned. For example, did he go out and buy a firearm? Did he look where this individual was? Any planning that led up to the murder, the prosecution is going to use to defeat the defense's idea that he lost self-control during this criminal act.
This is something that, if convicted, instead of going to prison, would end up in a psychiatric facility. Now, the judge, we know, has also called the defense to submit more documentation. That deadline, I believe, is tomorrow. What sort of things is this something where they have to kind of meet a certain threshold for the judge, or show some things before this is something that they can move forward with, similar to like Stand Your Ground is here in Florida?
Well, usually before a judge is going to want to rule or hear any evidence, they want to know, discovery, or they want to know what each party is going to be presenting to the court, so they have a little bit of time to research it. And like, what exhibits are we going to use? We don't want to sit here in court and argue over which exhibits are admissible. They usually want both parties to share the exhibits, and then they can determine and come to some kind of compromise what's going to be admitted. It saves the court a lot of time. But what I also want to make very clear, this is not an insanity defense. When you have an insanity defense, what that means is that you're found not guilty by insanity. That means you're acquitted, you go home. No, what this means is that if the jury buys that he was under emotional disturbance, extreme emotional disturbance, what that means is that instead of being found guilty of murder, he'll be found guilty of manslaughter, which would decrease his penalty from life down to 25-year max. So it doesn't mean that he's going to go to a hospital. He's still going to go to prison. He just has less exposure.
Now, I want to transition now, and let's talk about the Tyler Robinson case. He's accused of shooting and killing Charlie Kirk, and we learned today that his roommate and alleged lover as well received some limited immunity in exchange for a recorded statement and some communications that prosecutors want to use. So when we hear use immunity, which is what we heard from the prosecutors in this, what does that mean? What does that tell us? And what does that do to shield the roommate?
Well, this is one of the oldest strategies in our legal system. In other words, those who know the most usually get the least penalty. So what happens is usually before this immunity, there was what we call a proffer. A proffer is where you walk into a room and then you're going to pretty much tell everything that you know to the prosecution, but they cannot use it against you other than to impeach you. In other words, attack credibility. So what they've done is, sometimes when they need his testimony or they need him to testify against a defendant, they're going to say, listen, we need you to testify. We want you to tell us, under oath in order to acquire this conviction, in this case of the defendant. So what happens, they'll give him some kind of immunity. And a lot of times they'll give him, they'll say, I'll tell you what, we'll reduce your sentencing, or we're not going to come in and charge you if you tell us you had some kind of participation. Immunity just means we're going to protect you if you cooperate. In other words, if you want to help yourself, help us get this conviction.
So would that mean then if there were things that were found that could potentially otherwise lead to some sort of penalty or charges, that he is shielded from any sort of consequence from what they learned from these statements, or completely in general?
Well, I mean, it would tell me that if there was no risk of him being charged with anything, he wouldn't need any immunity. So they want him to kind of spill the beans, so to speak. They want him to come in and tell us everything you know, but don't be in fear that we're going to come in and charge you. So that's what they're pretty much telling. We're going to protect you, but you have to help us. We want you to come in. You want to testify. Most people don't want to testify, but in reality, and I assume he has representation. There's no reason to testify and ask for immunity if you have nothing to risk.
José Rivas, criminal defense attorney and one of our legal analysts that we love speaking with. Always enjoyed talking with you, Jose. Thank you so much. You do a great job explaining these things for us, and thanks for joining us today here on Florida Live.
Thank you for having me.
We are going to take a quick break.